In Indiana, we don't have DUIs, we have OWIs. Kind of the same thing though. And if you've been charged with an OWI or DUI, you need to know what it means. Here's the absolute basics of Indiana OWI. In Indiana, OWI stands for operating while intoxicated. Sprinkled in there is the actual term vehicle. So some attorneys actually call it OVWI, operating a vehicle while intoxicated, but it's all the same thing. So operating, were you in control of the vehicle? Vehicle, you can't just be sitting in a broken down vehicle that's incapable of being moved, even perhaps if it turns on. There actually has to be operation. Now, operation is broad, doesn't mean you have to actually be driving it, but the vehicle has to be capable of being driven. So don't take that for granted. A lot of attorneys do. Now, the second part is this while intoxicated. So many attorneys, and I've seen this Court of Appeals briefs and even defending other individuals, we find somebody down the road walking and the officer stops them and they're drunk as a skunk and their car is a half mile down the road and they say, hey, you're drunk now, car's over there, you must have been operating a vehicle while intoxicated. Hold on, wait a minute, stop. The state of Indiana has the burden of proof beyond a reasonable doubt that you were operating while intoxicated. So if you're intoxicated at point B, but your car is at point A, they still have to show that you're operating while intoxicated before you got out of that car. Don't take that for granted. That sounds kind of silly, right, Mark? You're stretching for things. No, there's Court of Appeals cases. People come into the hospital and they leave, and then the officers find them and say, we only been here for a half hour. You must have been drunk when you got here because you're drunk now. No. Court of Appeals will say it's very important to prove a nexus, meaning connection between the operation and the intoxication. Most of the time, if the officer sees you driving and takes your blood or breath shortly after, well, it's not going to be too big of a deal to prove that while intoxicated. But in accident cases where people are not in the vehicle when the officers arrive, this becomes a pretty big deal. Never take that for granted. Now, the third element is intoxication. Now, intoxication can be from alcohol, it can be from prescription medication, it can be from recreational medication, and it can be any combination of those three. So don't ever take that for granted either. Now, the state also has the option of proving intoxication a couple different ways. Rebuttable presumption that somebody blows 0.08 or higher that they're intoxicated. And it's rebuttable, meaning an attorney can disprove that or try to take chops at it to show it's not true. Also, if there is not a number, because there's no blood or breath, that happens sometimes. It's very rare, 2025 when this is being filmed, but it does happen. Now, if there is no number, the state of Indiana can try to prove intoxication through an impairment of a person's faculties, meaning the way they talk, the way they're standing, the way they walk. The old sobriety test, one leg stand, walk and turn. That's why the officer's having you do those. So operating while intoxicated is what they must prove when you've been charged with an OWI, sometimes called DUI. And DUIs always start as a C misdemeanor. They rarely stay as a C misdemeanor. Sprinkle a little bit of endangerment. You got an A misdemeanor. There's a kid in the car. You got a prior within 7 years. It's going to be a level 6 felony. Something terrible happened. It can jump up on felonies pretty quickly. An Indiana OWI charge is serious, but it's also defensible. Now that you know the basics, take the next step. Visit our website or give us a call, 317-632-3642. We would love to talk to you about your options. Most importantly, though, remember to always plead the fifth.